Oh, I want to pause it. Good afternoon, ladies and gentlemen. Today, we're going to take a beginner-friendly dive into the world of international arbitration. This session aims to provide a foundational understanding of international arbitration, discuss emerging trends, and explore practical issues. The topic is too vast for just an hour-long webinar, but we will do our best to present you a comprehensive picture. I am Reena Soni, Vice Chair of CIR NAP Programming, and it is my pleasure to introduce our esteemed guest for today's webinar, Nelson Edward Timken. With a career spanning over 3 decades in the legal realm, Nelson has carved out a distinguished niche as an arbitrator and mediator, adeptly handling a diverse array of disputes, including commercial conflicts, consumer issues, investor-broker claims, and attorney-client fee disagreements. Nelson's journey in the legal field began as a judicial law clerk with the New York State court system, where he gained valuable experience in navigating the complexities of commercial, foreclosure, and guardianship cases. Over the years, he has not only drafted pivotal decisions on motions and bench trials, but also played a crucial role in settling a variety of cases, showcasing his adeptness at finding common ground even in the most contentious situations. To further refine his skills, Nelson completed over 200 hours of specialized mediation training in both New York and Florida. His approach to mediation is particularly noteworthy, as he employs a modified facilitative style that emphasizes active listening and empathy, guiding parties towards mutually beneficial resolutions and often providing a more favorable alternative to prolonged litigation. Nelson is a fellow of the Chartered Institute of Arbitrators. He also serves as a chair qualified public arbitrator and mediator with FINRA and recognized as a qualified arbitrator and mediator by the Florida Supreme Court. Nelson holds a JD from St. John's University and an LLM in International Dispute Resolution from Fordham Law School. Through his firm, Timken Dispute Resolution LLC, Nelson has been consistently sharing valuable insights and trends related to ADR via his newsletter, The ADR Solution. Please join me in welcoming Nelson as he delves into the intricacies of dispute resolution and the evolving landscape of ADR. Welcome, Nelson.
Thank you very much, Reena. And
Sure.
Thank you to the Chartered Institute North American branch for having me here today.
It's our pleasure. So, Nelson, a critical aspect of international dispute resolution that has garnered significant attention and debate has been the investor-state dispute settlement, or ISDS. In the realm of international trade and investment, ISDS serves as a mechanism allowing foreign investors to bring claims directly against states for alleged breaches of investment treaties or agreements. And this system is designed to protect investors from discriminatory practices, expropriation, and other actions that could undermine their investments. And ISDS has facilitated a significant number of cases where investors seek compensation or other remedies for perceived injustices in host countries. However, it is not without its controversies. Critics argue that it can undermine national sovereignty, allowing corporations to challenge public policies that are in the interest of public health, safety, and the environment. Additionally, the complexity of these disputes often involves intricate legal questions and interpretations of international treaties, So my question is, how do you think ISDS can evolve to address both investment protection and the criticisms it faces regarding public policy and sovereignty?
Well, I think the first thing, and this is a theme throughout uh, many of the uh, hot topics in international arbitration, is that many contend that there's a need for increased transparency in the proceedings, that the process has to be made more open to the public, that awards and decisions should be published in order to alleviate concerns about legitimacy and accountability. In addition, um, there is a suggestion that treaties between the host companies and the investors should be more precise in defining the scope of investment protection and the standards for state conduct to help reduce the number of frivolous claims and limit the potential for tribunals to overstep their authority. Um, there also is a push for stronger safeguards for public policy to protect the right of states to regulate in the public interest, which has been one of the issues in ISDS. Also, there should be a greater emphasis on mediation and negotiation rather than a push directly to arbitration, which could help reduce the adversarial nature of the entire mechanism. The current system of tribunal appointment has been criticized for having potential biases, and some have suggested that a permanent investment court with a diverse and independent roster of judges could help address concerns about impartiality. Also, it's been suggested that there be a permissible greater community involvement, such as amicus curiae participation in these disputes. There has to be a better balance, in many people's opinion, between the need for investment protection and concerns about state sovereignty and public policy. It has to be more transparent, equitable, and legitimate, that fosters suitable investment while at the same time respecting the sovereign regulatory authority of the host countries.
Thank you for shedding light on that. Are there any recent cases or trends that illustrate how ISDS is adapting to these challenges?
I don't have any recent cases, but as illustrative of the situations that come to pass, you have situations in which a country, a mining company, for example, from country A invests in country B. Country B later enacts environmental regulations that significantly reduce the profitability of the mining operation, and the mining company, believing that the regulations violates its rights under the investment treaty between the two countries, initiates an ISDS case against country B. The case is heard by an international tribunal, which ultimately decides whether country B's actions were justified or if they violated the treaty. That's the kind of dispute that you generally have in these types of cases.
I see. Let's discuss another topic that is increasingly shaping the landscape of global business and legal frameworks: environment, social, and governance, or ESG consideration. In recent years, ESG has emerged as a critical component for businesses, investors, and regulators worldwide. And it reflects a growing recognition that sustainable and ethical practices are not just beneficial, but essential for for the long-term success in risk management. And companies are now expected to not only focus on financial performance, but also address their impact on the environment, society, and governance structures. So from an environmental perspective, there is an increasing emphasis on reducing carbon footprints, managing natural resources responsibly, and mitigating the impact of climate change. And social considerations, of course, involve ensuring fair labor practices, respecting human rights, and contributing positively to communities. So my question is, how do you see this trend affecting the types of disputes being brought forward, particularly those involving environmental and social issues? And if
Well,
possible, if you would share an example where ESG factors have played a crucial role in the outcome of an arbitration case.
well, there's been a surge in disputes related to environmental damage, carbon emissions, and compliance with environmental regulations. There also have been some of what's called greenwashing claims, which are claims that the underlying company exaggerated their environmental and social performance. I'm not aware at the moment of any specific cases, but there are contractual disputes which are being brought to state that companies have not complied with the ESG clauses in their contracts that require the parties to adhere to certain environmental and social standards. There have been disputes over the interpretation and enforcement of these clauses. Parties have sought to hold each other accountable for violations of the agreements, as well as investment treaty disputes between the parties and involving claims against host states for measures that negatively impact the environmental and social performance of their investments. The host states, of course, have claimed that these measures were necessary to protect the environment or promote social welfare. The bottom line is that ESG considerations have brought new types of disputes and disputes that are challenging traditional legal frameworks, which requires arbitrators and legal practitioners to develop expertise in ESG issues and to effectively address these complex disputes. The integration of ESG into arbitration also presents opportunities for promoting sustainable development and corporate responsibility. By holding companies accountable for their environmental and social impacts, arbitration can play a role in advancing global ESG goals and ensuring that businesses operate in a responsible and sustainable manner.
Thank you. I totally agree. Moving on to the hot topic of technology and AI in arbitration. In recent years, technology has revolutionized the arbitration process by streamlining case management, facilitating virtual hearings, and enabling efficient document review and evidence analysis. And this digital transformation has not only enhanced the speed and efficiency of arbitration proceedings, but has also expanded access to dispute resolution mechanisms. We saw that during, ever since the COVID time, how it has changed the dynamic. And especially in a global context where geographical barriers can pose significant challenges. And artificial intelligence in particular is at the forefront of these changes. And AI tools are being leveraged to analyze vast amounts of data, predict case outcomes, and even assist in drafting legal documents. And the technologies are helping arbitrators and legal practitioners make more informed decisions and manage complex cases more effectively. But there are also the ethical and legal questions. And my question to you is, what are some key concerns you think the arbitration community should address regarding the use of AI in arbitration proceedings? And how do you envision the balance between the benefits of AI and the need for human oversight in arbitration?
Well, there's no doubt that the integration of technology and AI into arbitration has brought undeniable benefits, including the democratization of the arbitration process, increased efficiency and cost reduction. But there are also issues that have to be addressed in order to ensure fairness and equity in the process. One of the contentions is that AI algorithms are based on historical data, which may contain inherent biases, which may, in the end run, cause discriminatory outcomes in decisions that are based upon AI. And that's one of the issues. The arbitration community has to develop mechanisms to identify and mitigate biases in AI systems in order to ensure fair and equitable outcomes for all parties. One of the other issues is that the processes in AI can be complex and opaque. Not everybody understands them. And therefore, not everyone is going to understand how decisions are reached. There has to be more transparency in the process in order to avoid a situation where there's a decrease in trust in the arbitration process, which raises concerns about the fairness of outcomes. The community has to make sure that there are understandable explanations for decisions which ensure transparency and accountability. The other issue, which I see as a major issue, is data privacy and confidentiality. The use of AI raises concerns about the collection, storage, and use of data. There has to be robust data protection protocols to safeguard the confidentiality of sensitive information and prevent unauthorized access or misuse. Akin to that is the issue of who is responsible. Should there be errors or biases in AI-generated outcomes? That has to be clarified. And it also has to be clarified how potential errors or biases will be addressed and rectified. My personal opinion is that human oversight will never be replaced by AI because there needs to be the infusion of human judgment and decision-making in the process in order to prevent there from being these issues in AI-assisted arbitration, so that humans remain ultimately responsible for decisions and can intervene in case of errors or biases. The other issue that I see is that AI tools are not accessible to everyone. There are parties that do not have the wherewithal in terms of the resources or technological capabilities to access AI tools, and thus it creates a situation where there is a disparity in power, in the power structure, which and there are also people that are less familiar with AI technology, so that all tools in AI should be equally accessible. By addressing these concerns, the arbitration community can harness the benefits of the technology while ensuring that arbitration remains a fair, transparent, and equitable process for all parties involved.
I see. Thank you for answering that. My next question relates to an issue that is becoming increasingly central to our field and to many others. Diversity and inclusion, often referred to as D&I. Diversity and inclusion encompasses a wide range of factors, including gender, ethnicity, culture, and professional background. And ensuring that arbitration panels are diverse helps in providing more balanced and comprehensive viewpoints, which is crucial when dealing with complex, multifaceted disputes that span different jurisdictions and cultural contexts. And moreover, a focus on D&I is vital for reflecting the global nature of the parties involved in international arbitration. It helps to bridge gaps between different legal traditions and societal norms, fostering greater understanding and respect. So it's not just a matter of fairness, but also of improving the effectiveness and efficiency of the arbitration process. It encourages creativity, innovation, and robust problem solving, a more equitable and sustainable outcomes. And my question to you is, what measures do you think are most effective in promoting diversity within the arbitration community? And has there been a notable improvement in diversity that you believe is setting a precedent for future appointments?
I think there has been a notable improvement in diversity, if only by virtue of the fact that there has been a raising of awareness in the community of these issues of diversity, equality, and inclusivity. I think many things that I'm going to state have already been done, but since you asked, I'm going to state them anyway. Data collection is one thing that would assist in the process of diversity and inclusivity, and that means collecting and publishing data and arbitrator appointments, tracking the representation of different genders, ethnicities, nationalities, and other relevant diversity factors. This can help identify disparities and track progress towards greater diversity, raising awareness, as I said at the outset, about the importance of diversity in arbitration and the potential biases associated with homogeneous panels is essential. And that can be accomplished through educational programs, workshops, and conferences that highlight the benefit of diverse perspectives in dispute resolution. Targeted recruitment is another thing that can help the situation. Institutions and organizations should actively seek out and recruit arbitrators from underrepresented groups. This can involve reaching out to diverse professional networks, such as specialty bar associations, establishing mentorship programs, which has already been done to some degree, and providing scholarships and fellowships for aspiring arbitrators from diverse backgrounds. Um, there has to be a more transparent appointment process based upon merit, ensuring that all qualified candidates have equal access to appointments. And that would involve publishing clear criteria for arbitrator selection, establishing diverse appointment committees, and avoiding conflicts of interest in the appointment process. Uh, Another thing that can be done is, and I think it already has been done in many cases, is to have organizations and individuals sign diversity pledges, committing to promote diversity in arbitrator appointments. These pledges can set targets for diverse representation, encourage the nomination of diverse candidates, and promote accountability for achieving these diversity goals. One thing that I am highly in favor of is implicit bias training. It helps to raise awareness of unconscious biases that may influence arbitrator selection. It certainly, and I'm speaking from personal experience, helps individuals recognize and mitigate their biases, leading to more objective and inclusive decision making. Um, there needs to be mentorship, networking opportunities, and professional development programs for diverse arbitrators to help them build their careers and gain visibility in the arbitration community to enhance their chances of being appointed to arbitral tribunals. And if that is done, it will contribute to greater diversity in the field. I think by implementing these measures, it will make significant progress towards creating a more diverse and inclusive environment. It will enhance the legitimacy and fairness of arbitration. And what's even more important, it'll bring a wider range of perspectives and expertise to the dispute resolution process, which will ultimately, in my view, benefit all parties involved.
Thank you for your in-depth answer, and I couldn't agree with you more on that. Moving on, ladies and gentlemen, as we continue our journey through the intricate world of international arbitration, let's take a moment to lighten the mood with a topic that, while serious, also lends itself to some intriguing and sometimes unexpected scenarios: geopolitical tensions and international sanctions. Now, navigating through geopolitical waters can sometimes feel a bit like playing an intricate game of international chess. Just when you think you've made a winning move, a new sanction or a sudden political shift can change the whole board. Imagine being an arbitrator and waking up to the news that a key party in your case is suddenly sanctioned, like getting a curveball in the middle of an already complex game. Talk about keeping you on your toes. And speaking of surprises, geopolitics can sometimes make arbitration feel like a high-stakes spy thriller. You might not get to wear a tuxedo like James Bond, but deciphering the tangled web of international laws and sanctions can be just as exhilarating. Geopolitical tensions and international sanctions, they can complicate arbitration cases. So my question is, how can arbitrators and institutions navigate these complexities, especially in cases involving sanctioned countries or politically sensitive disputes? Are there any specific regions or recent cases where these challenges have had a significant impact on the arbitration process?
You mean don't appoint Ukrainians to a matter involving a dispute involving Russian companies? I think that might be helpful. But seriously, um, the geo first of all, we have to understand that not everyone in this world plays well together. Not everyone gets along. And so there are always these geopolitical tensions and international sanctions that can significantly complicate the arbitration process. And they create challenges for the arbitrators and the institutions. What can we do? Well, I think uh, some of the things we can do is to conduct thorough research involving the relevant sanctions regimes and look into any applicable restrictions to ensure compliance with legal obligations. Consult with legal experts specializing in sanctions law and international trade to understand the specific implications of these sanctions to the arbitration. Communicate openly. It's always good to communicate. Communicate openly with all parties involved about the potential impact of sanctions on the proceedings and any limitations that they may impose. Make sure, as I joked at the outset, make sure that you appoint arbitrators who are independent and impartial with no political or economic ties to the sanctioned country or the dispute. Maintain strict confidentiality throughout the proceedings to protect sensitive information and avoid political interference. Ensure a fair and balanced process, giving all parties an equal opportunity to present their case and address the impact of sanctions on their rights and interests. Um, Carefully consider the choice of law clause in the arbitration agreement and the choice of law that you select, as sanctions may affect the enforceability of the award. Um, Explore alternative enforcement mechanisms, such as recognition and enforcement in jurisdictions which are not affected by the sanctions. Develop strategies to mitigate the impact of sanctions, such as restructuring the transaction or finding alternative payment mechanisms. Um, Arbitration institutions should develop clear guidelines and protocols for handling cases involving sanctions and politically sensitive disputes, and they should provide training for arbitrators and staff on sanctions law and the complexities of dealing with politically charged situations. In addition, they should offer resources and support to parties and arbitrators navigating the rough waters posed by sanctions and geopolitical tensions. Um, Engage open communication and dialogue between the parties, arbitrators, and institutions to find mutually acceptable solutions within the legal and political constraints. Another very helpful thing would be to consider mediation or other forms of alternative dispute resolution to facilitate amicable settlements and avoid protracted legal battles. Um, it's important to remember that while sanctions are a legitimate tool of international policy, they shouldn't undermine the integrity and effectiveness of the arbitration process. By upholding the principles of neutrality, fairness, and due process, arbitration can continue to play a crucial role in resolving cross-border disputes, even in the face of geopolitical challenges.
Thank you. I appreciate your answer, and I totally agree with it. Let's move on to the next topic. With the increasing digitization of arbitration, and I know you touched upon this topic a little earlier, the cybersecurity and data protection being so crucial. What are the main cybersecurity threats that arbitration institutions and parties need to guard against? I mean, and if you can elaborate on some steps taken to improve cybersecurity in arbitration to protect the sensitive data, I would appreciate.
All you have to do is look in your email every day, and you'll see the main issues that the digitization of arbitration has resulted in, such as data breaches, which cause unauthorized access to confidential arbitration, such as sensitive case documents, financial data, or personally identifiable information. These can have severe consequences when hackers exploit vulnerabilities in IT systems using phishing scams, or when they employ social engineering tactics such as setting up false websites to gain access to the data. In addition, ransomware attacks encrypt an organization's data, making it inaccessible until a ransom is paid. To answer your question directly, to mitigate these threats, arbitration institutions and parties should adopt a multi-layered approach to cyber security, which includes implementing strong access controls, encrypting sensitive data, regularly updating software and systems, conducting cybersecurity awareness training for all employees, which many companies have, and developing incident response plans to address potential breaches promptly. They should also consider investing in cybersecurity insurance to protect against financial losses in the event of a cyber attack. They should also establish clear cybersecurity policies and procedures that are regularly reviewed and updated to address emerging threats. By prioritizing cybersecurity and data protection, arbitration institutions and parties can safeguard the integrity and confidentiality of arbitration proceedings, which will ensure a secure and trustworthy dispute resolution process.
I agree. Thank you for answering that. Moving on to my next question, I want to dive into a topic that adds an intriguing twist to the proceedings: third-party funding. Now, if you've ever wondered what it's like to have a financial superhero swoop in to support your case, third-party funding might just be the plot twist you're looking for. Imagine this: you're about to embark on a daunting arbitration battle, and suddenly, like a character in an action movie, a third-party funder appears, offering to bankroll your case. It's a bit like having a fairy godmother, but instead of turning pumpkins into carriages, they turn legal expenses into manageable payments. And all you need is a strong case, and voila, you've got yourself a financial backer ready to shoulder the costs. Now, who knew arbitration could have its very own version of Shark Tank? So third-party funding is gaining traction, but it, like everything else, it brings up ethical and conflict of interest concerns. And my question to you is, how do you see the role of third-party funding evolving in the landscape of international arbitration? Do you think there should be more regulatory measures in place to address these concerns? And if so, what kind?
Okay, so third-party funding is like, whose case is it anyway? Where there are obviously conflicts between the third-party funder and the party whose case it is originally. But the very positive thing about third-party funding is that it provides a valuable source of funding for claimants who would otherwise lack the resources to pursue their claims. And so, in a way, it opens up the horizon for people to vindicate their claims. So that's the good part about third-party funding. But its rise has also raised ethical and conflict of interest concerns that have to be addressed. So your question is, what can we do? I think the first thing is that you're going to see increased calls for mandatory disclosure of third-party funding arrangements. That would ensure transparency and allow arbitrators and opposing parties to address potential conflicts of interest. I think that you're going to see the development and adoption of ethical guidelines for third-party funders, which are going to address issues such as case selection, control over the proceedings, and potential conflicts of interest. Some jurisdictions may introduce specific regulations to govern third-party funding in arbitration to ensure fair practices and protect the integrity of the process. You're going to see a greater degree of arbitral institutions and tribunals conducting more rigorous conflict checks to identify any potential conflicts. Parties and funders will need to perform thorough due diligence to assess the merits of the case and the reputation of the funder to avoid the perception of impropriety. There has to be the use of independent counsel, not affiliated with the funder. And there is going to be, in my opinion, greater scrutiny of counsel that do work for these funders on a repeat basis in terms of what conflicts they may have. There's going to also be, I think, diversification of funding models so that there'll be hybrid funding models that combine third-party funding with other arrangements, such as financing arrangements that utilize insurance or contingency fee arrangements. I think you're going to see some nonprofit organizations get more involved into third-party funding for public interest cases, and those with limited commercial viability, which otherwise would not be accepted by third-party funders. I think funders will likely become more selective in choosing cases, focusing on those with strong legal merits and a high probability of success. I think third-party funding is going to influence settlement negotiations because the funders are going to necessarily push for early settlements to secure a return on their investment. And I think that you may see third-party funders, third-party funding used strategically to pursue cases that have a broader social impact beyond the individual dispute, such as those that set legal precedents or promote policy change. So I think in in some, you're going to see third-party funding evolving into a model towards greater regulation, transparency, and ethical standards. And that will address concerns about conflicts of interest and ensure that third-party funding remains a legitimate and viable tool for accessing justice, while at the same time avoiding some of the things that make people raise their eyebrows about third-party funding. I think it's going to continue to play a significant role to expanding access to justice and level the playing field and contribute to the development of international arbitration as a whole.
Thank you for addressing it very thoroughly. As we journey through the world of international arbitration, let's pause for a moment to discuss a topic that can feel a bit like trying to find your way through an elaborate maze: cross-border enforcement. Imagine this: you've just won an arbitration award, you're on cloud nine, picturing your well-earned victory and how you're finally going to collect what's owed to you. And then the reality hits, and you realize that enforcing this award across borders is a journey filled with twists, turns, and the occasional unexpected detour to get past the next legal checkpoint. It's a test of patience, persistence, and perhaps a touch of legal acrobatics. Nelson, given the often complex and sometimes downright entertaining challenges of cross-border enforcement, what are the best strategies for parties to navigate these hurdles effectively? And how can they ensure that their hard-earned arbitration awards are enforced smoothly across different jurisdictions?
I think the first thing that is important is that they ensure that the arbitration agreement clearly defines the seat of the arbitration, the applicable law, and the procedure for enforcement. This will help avoid ambiguity, such as ambiguity that certain jurisdictions will find in the New York Convention that make enforcement of the award more difficult. I think they need to conduct through due diligence on the counterparty to be able to assess their financial standing and assets before entering into the agreement. This can help avoid situations where enforcement becomes difficult due to a lack of assets. Consider the reputation of the chosen seat of arbitration for its pro-enforcement stance and its adherence to international conventions such as the New York Convention. This can increase the chances of successful enforcement in other jurisdictions. Engage legal counsel with expertise in international arbitration and enforcement proceedings in the relevant jurisdictions. They can provide guidance on navigating the rough waters of the legal and procedural complexities and increase the chances of successful enforcement. In some cases, consider alternative enforcement mechanisms such as mediation or settlement negotiations that may be more efficient and cost-effective than pursuing formal enforcement proceedings. I think by following these measures, parties can increase the likelihood of successful cross-border enforcement of their arbitral awards.
I agree. Would it be too much to ask you to mention any recent case that you can think of where enforcement of an arbitration award was particularly challenging?
As before, I don't have a recent case handy, but I will mention a few ways in which the interpretations of the New York Convention can make enforcement more challenging. There is the public policy exception that some courts will throw into the mix in order to enforce a ward by saying it's against the public policy of their country. Um, the court can refuse enforcement if the arbitration agreement is invalid under its applicable law, which of course they will define. There are different approaches, such as the law of the seat of the arbitration of the law or the law of the enforcing state, which can vary the interpretations, which can lead to different outcomes on the enforceability of the agreement and consequently the enforceability of the award. There can be a claim of due process violations. You did not let the party present its case, or the award was not made on the basis of the party's submissions. That can cause a court in a jurisdiction to refuse to enforce an award. There can be a claim that the particular dispute was non-arbitrable. That's Article 5, 2A of the New York Convention. In addition, you face a lack of conformity in national laws, which can vary significantly from jurisdiction to jurisdiction. There are so overall, the New York Convention has been instrumental in promoting the recognition and enforcement of arbitral awards, but there are differing interpretations of its provisions, and varying national practices, continue to pose challenges. Efforts to harmonize interpretations and promote greater uniformity in enforcement practices are ongoing, but there still is a lot of work to be done on these issues of obtaining enforcement of an award.
Sure. Well, thank you. Nelson, I have a comment and a question from our audience, and it is from Lester Renard, and it's in regard to our discussion regarding diversity. Mr. Renard says, Mr. Timken rightly spoke about the need for diversity in the appointment of arbitrators. It's an issue that everyone agrees with, even if it's for the appearance of political correctness. But as to what concrete measures are proactively been taken to make it a reality is the proverbial elephant in the room. The appointment of arbitrators to international tribunals tends to revolve around recognized names of predominantly aging white males with little opportunities for others who are not part of this club. How can we change this reality in earnest to make this process truly diverse? This is his question.
One of the things that I would do, and this is just my opinion, obviously, is that I would get diverse individuals involved in the arbitral process by giving them more exposure to the parties. And how would I do that? I think one of the ways that I would do that would be by putting them in a program of internship where they would work with the arbitrators, perhaps as a tribunal secretary, in order to give them more face time with the parties. I think part of the problem is nobody wants to trust their $200 million case to somebody that they don't know. They want someone that they know and that they can basically predict what the procedure is going to be. I mean, think about it. You have a case, you have a client, and you don't want somebody who is a wild card. You want somebody that you know, and that's one of the problems. But if you give these parties FaceTime, I think that would be a logical way to get people's foot in the door.
Thank you, Nelson. We have a few minutes left, and I have an important question, and it is about our young practitioners.
Okay.
And I want to ask you, how can practitioners and young practitioners and institutions best prepare for these emerging trends and challenges in the next few years?
Well, my personal opinion, and I've heard this from people who have gotten their foot in the door by doing this, is that I think the first thing they should do is to try to obtain an internship with a firm involved in international arbitration that permits them to get some exposure to cases involving international arbitrations and learn the foundations. But that's my particular feeling. I think the other things that they need to do would be to develop a strong foundation in law and arbitration by building a solid understanding of the legal principles and procedural rules that govern international arbitration, and by staying abreast of the developments in case law and jurisdiction. Fortunately, many of the very prestigious firms that practice international arbitration put out blogs, and their websites have a great deal of information that you can access at no charge at all.
Well,
And
thank you. I was going to ask you any key resources or experiences.
yes,
So yes, please go ahead and
absolutely.
mention
I
those.
mean, and this is not a plug. I have absolutely no connection to this firm at all. But if you go to, for example, freshfields.com and look at their website, they have a tremendous amount of resources that you can access. If you go to the institutional providers, such as the ICC and the LCIA, and take a look at their website, they have a tremendous amount of information. They have decisions, awards, and decisions that you can access. I think that is one of the crucial things. The other thing that I would suggest is to develop an expertise in an emerging area, such as ESG-related claims, which we talked about today. Technology-related disputes is another good area. These areas are experiencing significant growth and offer opportunities for young professionals to develop expertise and stand out in the field. I think
Thank you.
those are
Thank
some
you.
suggestions.
So as we come to the end of today's webinar, I'd like to thank everyone for joining us in this enlightening discussion on international arbitration. We've covered a range of topics from the challenges of cross-border disputes to industry-specific issues and emerging trends. And it's clear that as global trade and investment continue to grow, the role of arbitration in resolving disputes fairly and efficiently will become increasingly vital. I hope you found the insights shared today valuable and that they will help you navigate the complexities of international arbitration more effectively. Whether you're dealing with construction, energy, technology disputes, the principles and practices we discussed are crucial for achieving fair and just outcomes. And before we conclude, I would like to extend a heartfelt thank you to Nelson. Your expertise and insights have greatly enriched our understanding today. and we're deeply grateful for the time and effort you put into preparing for this session. And to our audience, thank you for attending this webinar. Your participation is what makes these discussions truly meaningful and impactful, and we look forward to seeing you at our future webinars. We have the next one is on July 10th at 1 p.m. And we look forward to seeing you there. And for more information, you can check our website. Have a great day, and thank you once again for being part of this important conversation.
Thank you.
Bye-bye.